I would like to extend my heartfelt wishes to Art of Law Project Nyay for providing a learning platform where the law students across nation can listen to the stories of real professionals, the struggles, obstacles, and the successes.
So, hello and welcome to another episode of Vidhisamvad. Today we have with us the bold and young Mr. Advocate, Mr. Advocate on record, Mr. Kunal Yadav. Good morning, sir. Thank
Thank
you
you.
so much for being here, and I extend my gratitude from me and my team for you to be on the podcast. So,
Thank you for having me here.
So, sir, this may seem like a generic question, but since we all know that the decade of 2000 to 2010 is usually famous for people pursuing engineering or medical studies, so what inspired you to be a legal student back then?
So the time when the engineering was at peak and the law was also evolving at that same time, CSCS course in 2007 was also very prominent. And I thought I should do something for the society, so I have to join the law. Because as you know, legal profession is a noble profession. For the simple reason is that we as the lawyers have to preserve the moral sanctity that in society. So I thought I should be more focused. We should more focused and more emphasize on the law aspect, and especially when the turning point of me joining in the law course was when I heard about this Jessica Lal murder case. The trial court had convicted Manu Lal in 2006. So in fact, when I was going through the judgment and the brief status of that case, so I thought I should be more inclined towards criminal litigation. The thought of my first thought that I should join the criminal litigation for 2 3 years after I finish off my law course. So as soon as I graduated from my law course, I started doing trial practice in criminal law for 2 to 3 years with the legal doyen. Ms. Seema Gulati and Subhash Gulati are the legal doyens of criminal justice system. So they have been in there in the criminal trial for 30 years. So I thought of doing little bit criminal trials with them. For 2 to 3.5 years, I learned a lot about criminal trials. Then I shifted to civil litigation after 15 16.
Yes, sir. So, while being in law college, were you like an all-rounder student, or you basically focused on studies back then?
No, no, I was not very good in studies actually. There's a myth. These are two myths. One myth is that one who is not good in studies, he can't or he or she can't excel in this legal profession. That's not certain a criteria. I was good in criminal law. So we have like in theory semester we have CRPC one and two, like IPC one and two in that time. So I scored good marks in criminal law. So my basic inclination towards criminal subjects moved in the year 2008 and 9.
So, recently the rolling out of the different laws, such as the BNS and three different laws. So, once you've studied IPC, CRPC, and all of these codes, and you've practiced them for 10 years now, and then suddenly there is a change of the trend. So, how do you see it particularly?
Also, drastic shift from the one which is in prevalent these three laws which are the foundation of criminal justice system. Now we have to move towards these three different laws: BNS, BNSS, and the third one is evidence act, I guess.
So, is it easier to cope up with these laws as a law student, or is it a little difficult?
It's a really challenging task. Actually, we have to go through the particular sections what they have tried to inculcate in these new acts because it will soon be starting from July 1st.
Yes, sir.
So the old cases will be acted as a retrospective effect. It will not be as a prospective effect. So the new cases will be registered as per the BNS and BNSS, and the whole trial will start. The new cases will be started. Will be coming from this. Will be covered under this BNS and BNSS. So it will be challenging for the lawyers to actually go through the whole act, and if in fact the judges have to go through. the PNSS and all these three acts, and because it's a challenge for them also to go through the all three different acts.
So even for the students currently, they are saying that
Yeah.
we'll have to read the older laws
Again, because
and
the
the
section
newer
has
laws.
changed, certain things they have amended in this BNSS thing. So the whole section has changed. For example, in the 438 and speed debate, now it is 528 something, the new act. The concept will remain the same, but they have changed the sections and something they have tried to add in those sections. So we have to look and see what.
So because during my internship, I've usually seen that people don't call it murder; they just call it 302 directly. So it's a bond trend, and it's difficult for
Yeah,
you
it is
guys.
difficult for the investigation officer also to register the case because the section has changed. CO2 is something different. Now he has to, he also has to go through the act and he have to see what are the repercussions of this section. So it all depends upon the implementation, how it is going to implement in coming years. Otherwise, because the concept will remain the same, the conceptual things will never go away. It's
Yes,
very
sir.
difficult to mug up the sections and also for the judiciary aspect, the one who are preparing for the competition, it will be very difficult for them to mug up the new section which is added up in this all these three acts.
So
Challenging for the lawyers also, for the teachers also, for the faculties also, as well as for the judges also.
yes, sir.
How to be as a lawyers and the judges will cope up with this new rules. Time will tell.
So being a law student nowadays, we see a lot of things such as mediation competitions, trial advocacy. Then we see moot court competitions. So with you being a student, which of these three like you excelled in or you participated in?
I was a member in Moot Court competition in 2000, in the year 2008 itself. I
Uh,
participated in only one competition, the Moot Court. However, it gives an upper edge to the law student. So it will enhance their argumentative skills, their persuasiveness skill, and how to represent your case in a simulated courtroom setting. But there is another myth which I would like to explore, direct to the readers, that if you have not done any moot court competition till date, it's not a criteria that you won't succeed in the legal profession. I have done only one moot court, and still I've done well, I think.
yes.
But post-COVID era, the certain things have changed. Like post-COVID era, the legal education has slightly shifted to the virtual hearing, and the courses have also little bit changed a bit.
Sir, so what we have usually seen is like when we practice the moot court sessions and all, they are very, they are still practiced with a very traditional method, whereas real life courts are very different from what I've seen from my experience. So, how do you think the whole moot court preparation affects the real life court performance in general?
No, it doesn't impact anything. Matlab, you mean to say in a moot court competition, it's just like the same thing. You just have to be perfect with the law, legal preparation, and you have to be very sure about the fact that the on the grounds on which you have to argue before the court, you have to you have to know the judgments very well. The same things goes to the in the real court practice. It doesn't make any difference. So if you are arguing before moot court commission, it does give you an upper edge that you your argument skill can be a better. Like if you have done 3 4 moot court competition and then after that you have decided to go to the litigation and then you started arguing the matter in any matter like criminal or civil matter. So it gives you an advantage in terms of it gives you a confidence in your arguments. Your legal arguments becomes more better if
Experiences, how real life experience is not impacted due to moot court a lot.
yeah. So In the real life experience, it is actually very challenging. You sometimes you have to update with your day-to-day judgments of Supreme Court and the High Courts. Sometimes the question posed by judge, which you don't have the answer to that question. Suddenly, uh, so basically it's a test. If you are just coming from a middle position to directly join the litigation, sometimes you have to face a lot of questions.
So basically, being a student, what we see is for especially for students who come from science background, we don't have too much habit of reading a lot. So what happens is when we are doing our research, judgments are not usually very small. They are very lengthy and very hefty. Like sometimes they are 500, 600 pages. So according to you, what is that one suggestion that you can give to students who find it difficult to read judgments as per now, and to increase to have a good research skill?
So the only thing the law student can become a good researcher by just reading the judgments of different high courts of even the tribunals, consumer courts, and Supreme Court judgments also. You have to have understand the rational legal position of various laws that is attached to it. There is no shortcut to it. You have to have go through all the judgments from bottom to top. There's no shortcut of reading the lines between the paragraphs. So you have to continuously read the judgments of different areas like criminal laws. You have so many judgments on different aspects. So once you continue reading these judgments all together, so it will create a good impact as your legal knowledge also gets improved. You keep reading the judgments and of every law, whether it's a service law versus matter related to education, matter related to appointments, civil laws, tenancy cases, and so cases whatsoever. Only then such knowledge that you inculcate by reading the judgments that will inculcate to your drafting portion also.
Sir, so basically, we have seen that you have also completed your LLM in the year 2014. So nowadays, what we see is people generally there is an idea that is being propagated around students, that is only if you want to go into the teaching line or academia is when you do your LLM. So what is your stand on this particular statement?
See, LLM is you can pursue LLM at any point of time. LM basically, if you want to go to the teaching line, that's the good thing. Matlab, you have to have upper you have to have a degree to have to pursue your career as a teacher or as a faculty member. So if you want to do LM in a corporate law, so it will have an upper edge. It will create a good impact on your legal education. For example, I did my LM in corporate law from Jindal Law School. When I was started practicing 2012 itself. For 1 year, I dropped that practice and then I started doing LLM for 1 year. It was very intensive experience. So I gained a lot of information. I gained got a lot of knowledge in corporate law, banking law, and financial law, and that is really helpful in profession also because we do IBC matters also. So it is really helping a lot when in terms of doing LLM when you're specializing in particular set of law.
So basically, it's a normal norm that you have to do LLM only when you're pursuing academia, or is it also
Yeah.
good in?
Otherwise, if you want to do for yourself, you want to gain some knowledge on, if you want to gain some knowledge on particular set of law, for like there's several courses for LM, like 1 year course. For example, international material law, corporate law, criminal law, taxation law. If you want to have gain more knowledge on that particular subject, you can do and you can go ahead. You can do 1 year LM, 2 year LM.
Sure.
But in practice, it will not create
Uh,
Litigation, you have to have
okay, so while practicing, it's not that important, but if you're going towards
not
the
that
field of
important.
academia, okay, sir.
For academic purposes, it is much more important.
So usually I've also seen people creating a divide between corporate law and litigation. Like there is a sharp divide, but still, as we see that you have done corporate internships before coming to litigation practices. So what is that one thing that has helped you from corporate firms? That has helped you, boost your career in litigation as well. What is that one particular thing which is common in both of them?
See, I started doing internship. My first internship was in criminal law. Then I started my second internship was in IPR. For IPR, what I worked with Cyprus law for 2.5 years. So I
So
gained a lot of
it wasn't clear which platform.
Cyprus law firm. So
Yes.
I worked when I was in fourth year of nursing. I worked with them for 2.5 years. So I get to know so many things about trademarks and copyright. Then I shifted towards the criminal law because I always wanted to be a criminal lawyer from very first instance. Then if I working, then I started working towards criminal trials. I started doing corporate work much later in 2018 itself, when there was a new act which popped up in this legal area now, IPC. There were so many foreign cases which were going around in this across the nation. So the one thing, what, what was the question that you repeat, please?
So the thing is that what is that one thing that you have taken from corporate firms has helped you boost your career in litigation as well? What is that one common thing?
Corporate, I have not done much corporate internship.
Okay, sir.
So
No, no.
I've done
Uh,
more in litigation.
I'm so sorry. I'm so sorry. I'll rephrase my question. How is working in different firms, interning in different firms, helped you in your private litigation? What is that one thing you take from that firm internship?
It gets a good exposure. I had get so many good exposure from working with so many seniors. Especially, I had gained so many wealth of experience in civil law, service law, criminal matters. So, on the other aspect, when you are working in a corporate law firm as an in-house counsel, that's a different conversation, and that's a different field. So there are
So
two tension between corporate law and the litigation part. In corporate also there is a litigation
yes,
where
sir.
you have to deal with merger and acquisition, litigation between various persons. But if you're talking about the criminal litigation, that's a different aspect altogether.
So, sir, as we all know that you're the legal counsel representative for National Highways Authority of India, my first question would be, how is it working at NHAI, and how does one get to be the legal representative of a public entity?
See, as a counsel of NHI, I have handled a few matters in land acquisition, arbitration appeal matters also in the district courts and high court and Supreme Court also I am dealing with. So it's an enriching experience to be part of this government entity and to represent on behalf of the government. You need to take certain things into consideration while representing the state government. Because the road sector is one of the basic pillars for national economic growth, going to its rolling movement of goods and public and can contribute positively towards several sustainable development goals. And for that, you have to go through the MOT guidelines. You have to be in particular. You have to go in through the guidelines and the rules and regulations which covers the interest of NHAI. So far and so forth, it is good. It's turning out to be good experience. Which I can
So, one question out of topic, but have you ever interacted with Nitin Gadkari, sir?
No, 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 not yet, not yet. I didn't get the chance. I did get the chance to meet 2, 3 years ago. It was a function in Vigyan Bhavan. I get to meet him, but didn't get a chance to meet in person. I'm sure in coming times I would get the chance to meet him. Let's see, fingers are crossed.
Sir, so one question that we missed was how does one lawyer get to be the legal representative of National Highways Authority of India? What is the pathway to that particular position?
No, see, you have sometimes the only pathway is they, they give the advertisements for certain things. I won't be disclosing this answer this question because it includes certain, privacy.
Sure, sir, sure, no issues. So recently, as we are seeing that there are a lot of highways being constructed in India, we have
Yeah.
just doubled our highways network, and currently we see a lot of outrage when it comes to being constructed highways because a lot of trees are being cut down. So when you're
No,
representing NHAI in the apex court or in any other court, how do you legitimize the felling of trees in the first place? How do you legitimize? Because we understand the fact that development and environment couldn't go together. So how do you legitimize your stand if the trees are being cut down out there and people are, filing petitions against the NHAI and all those things?
see, first of all, resilient road infrastructure plays a vital role in economic and sustainable development. So, for laying down new roadway pavements or maintenance of existing roads, these are resource-intensive activity, which results in environmental damage through greenhouse gases, emissions, air, water pollution. So, first of all, the only thing that is required is environmental clearance, which you must have heard about. It is mandatory for highways projects under environmental assessment notification. There are several other laws which covers like EI notification, Water Management Act, coastal regulation, zone rules. So it covers the agenda of highway projects. So in the pursuit of sustainable future, national highway development has evolved beyond connectivity to include environment-friendly practices. So NHAI has taken noteworthy steps to promote green cover along the national highways. For example, creation of Amrit Sarovars and innovative use of recycled construction material gas cells help to balance ecology while developing new corridors of growth for the nation. So particular balance has to be sustained as
Yes.
I have just discussed about. So NHAI is also laying emphasis on monitoring of plantation of trees. It has done over 4.13 lakh saplings has been planted under the aegis of Azadi Ka Amrit Sarovar. It was organized on 12th of July 2023 itself. Because through determination of proper alignment of NH project, it has become very critical. You have to look certain aspects before you selecting the route or alignment of the national highways, like cost of the land, cost of the building establishment, like shifting of utilities, construction cost, and the cost of safety features also, transportation cost, maintenance cost. So all these factors you have to look from before you go further.
So, from your experience in Supreme Court, what we usually get to hear is that hearings in Supreme Courts are usually nowadays it's usually in the English language. Is it true or is it false?
Official language in the Constitution of India also, the official language is English also, English only. So it is better to abide by the rules of Constitution and the Supreme Court. This is the official language also. Better to use English rather than using Hindi.
Sure, sir.
Hindi is often mostly used in district courts or rather these days Hindi is being used in high courts also. But it is better the lawyers who are practicing Supreme Court have to maintain some decorum in terms of speaking in a certain language that is already prescribed in the Constitution. That
Exactly, sir.
has to be considered by the lawyers.
Sure, sir. So, also one more thing, as you're a first generational lawyer, even I am a first generation lawyer,
Yeah.
and the thing is that I'm going to be a first generation lawyer. So sorry. And there are a lot of students who are pursuing law in current situations who are going to be first generation lawyers soon. So, being a first generation lawyer, how difficult was it for you to settle down in the industry? Was it difficult? Was it easy?
See, the time between 2002 to 2007 was very bit tough. Before COVID, So we started practicing 2012 itself with the in the criminal law in criminal trial. So it was initially very tough to analyze the list, court list, and to appear before the court. You get shaken, you get nervous while you are arguing the application. Sometimes you need confidence from the senior that okay, you just argue the matter and I will handle it. So mostly that has been done by the seniors. A lot of help has been aided by the seniors in the initial period of time. So basically, litigation, the pay scale is very, very. It's a basic issue that is following from past few years. So litigation, you don't get anything. The
Yes.
minimum I used to receive in 2012 when I used to practice in trial practice, the seniors, basic minimum pay 5,000 rupees I used to get. How hard is to to sustain in this profession by only getting 5,000 rupees in the initially and getting it for 1.5 years. Because the whole purpose was to learn the key aspects of criminal trial or the litigation area, but nobody teaches you. Only you have to move yourself forward and grab that opportunity and learn the whatever you are into the trial, either civil or criminal. I have taken 3 4 years to settle myself in this litigation because my whole aspect was to learn as much as I can learn this in this 5 years. It will be very beneficial for me, and it will turn out to be a boon for the first generation lawyer in the second stage of life.
Also, sir, what is the toughest part of the preparation for the advocate on record exam, and what are some of the key learnings which you would like to share with the audience for them to make this exam easy for themselves?
The, Before coming to the question, the last question that you asked about this first generation lawyer and all this stuff. So when we used to practice in a trial court, when we used to have monthly digest cases list, we used to get monthly, weekly digest list. We used to refer to the cases of Supreme Court judgments and High Court judgments. Now, after COVID, everything has come into a single place. After digitization of certain definition of district courts and High Court and Supreme Court, all the things have consolidated to the same place. So now you can refer to live law, bar and bench, if you had to look at judgments. Now it is easily accessible. In my time, it was very difficult to to go through judgments. You have to open one page and the second page, and you won't find the judgment of your favor. Then you have to wait for the another weekly digest law digest journal. Now it has become more feasible and accessible for the law students to actually go through judgments online. The digitization of things is really a pain for boon for the lawyers as well as for the law students also. Now coming to the advocate and record examination, it was not easy first of all in the beginning. I My first attempt was in 2018 itself. I started when I appeared in the first examination. I didn't clear in the first examination. Then I took a break, and then the COVID thing came. Then I waited for 2 years, and then I appeared in the second examination. I couldn't get through it. Then I lost all hope, and I thought, no, I should give it up. I should not appear for the over examination. I couldn't clear in the two examination. Then there's no point to give a third time. To a wastage of time. Somehow I kept my hope high, and appeared in the third time, and I cleared it in a flying colors. So basically, you should not give the hope. You should just keep on practicing, keep on work hard with sheer perseverance, and hard work is all required. Because I was practicing Supreme Court since 2016, and I was watching it from from very beginning about the daily day-to-day practice in Supreme Court, how the matters being filed, the registry practice, the listing of cases, and all these things. So it was very important for me to be a part of this institution in the very first place. To establish your independent practice, you have to clear this your examination if you want to see yourself much ahead in the coming 5 years of legal profession. Earlier, I had also given judiciary examination, but I couldn't get through it, so I thought of clear this AOR exemption first, and it will be very fruitful for me in this legal profession.
So also some tips or suggestions that would help the upcoming aspirants to clear their exam easily, or something, some learnings that you would like to share from your side.
See, as I've already discussed this question in my earlier in few articles and videos also, I've discussed this in detail. Like who wants to, currently last day only in the year of examination, the one paper has been cancelled because this year they had tried both modes. First is computer based mode, and second is the same pattern through writing based mode. So the one paper has been cancelled last yesterday. Now the one who were appearing for online exam, they have to come in Delhi to appear for this examination in the written mode. So how difficult is for them to come to Delhi in the second examination all of a sudden? So this thing have to be seen. This is unforeseen circumstances, but people need to study a lot. They need to study the judgments of Supreme Courts, because the criteria of clearing AGOR examination, as you must be aware about the certain condition that you have to add 4 years of practice and 1 year of practice as in with an senior AOR, and then you are eligible to appear for an AOR examination. First is your writing should be neat and tidy. Second thing is your legal knowledge should be very accurate, and you should be well versed with the judgments of Supreme Court and High Court, because there are four papers in your examination: practice and procedure, drafting, professional ethics, and leading cases. So you have to have all the leading 64 judgments on tips, and you have to revise them thoroughly, because the level of examination that they have been conducting from past 7 8 years is very tough.
So also congratulations on starting your own law firm. So so sir, what is the best part of owning or founding your own law firm?
See, at at the end, you have to have your own firm. You can't work with seniors for 20 years, almost 25 years. The last I have worked with senior with Mr. Pradeep Rai sir, who was former vice president of Supreme Court Bar Association. So you can't work with senior for too lengthy period of time. There's a time comes where you need to establish your own practice. So I thought there was the time that I should, after becoming an AOR, I should start my own practice. I was though a bit late. Mostly my colleagues and other colleagues, they had started practicing independent practice much late, much before than I started it mine. So there is no such a hard and fast rule that when you have to start your own independent practice. You can start even practice after even 3 years of spending your life in legal profession. There is no such hard and fast rule. But after I started a bit late, after 10 years of getting so much of abundance of experience with so many seniors in Delhi. So I started a bit late. I have something different in mind. So it is turning out to be good as an independent practitioner. One has to have their own law firm in the end. You can't stick with the senior till you get old.
So what is the best part of owning your own law firm? The best part of it.
Best part is that you need to that I take certain decision what I feel what is right. Earlier, with when you're working under some senior or senior advocates, you can't take your independent decision with respect to the filing, with respect to the case, so that you tell it to them. I can take my certain decision. I can take my certain action on the cases. What I have to do next. What next? What I have to argue on the next date of hearing. This independence and freedom is more important, and which I am cherishing it now at this time. Independence and freedom, that is more cherishable thing.
So, and what are the challenges of owning your own law firm? There definitely must be a lot of challenges.
Challenging, yeah, there are various aspects. First, you have the finance thing is the basic basic issue that one have to go through while operating their own law firm. The clientage is the base, the another issue which one have to deal with it while operating their own independent law firm. So how to build a clientele and how to how to establish our own independent practice. These are the two main aspects of which we go through every single day. How to build the clientele, how to get the cases, and how to run the law firm. How to how to get the work from the associates. What are the tricks that you can take the work from the associates. You have to teach the associates also sometimes. You need to teach the associates, you know, teach the interns also, the specific cases that you assign to them. So all these things, keeping these factors in mind, it's really challenging for the law firm or independent law firm to deal in all aspects.
So, what skills should one have to intern at Kunal Yadav and Associates?
And you can just send the mail and I can just go through your mail and just I can approve depending on the number of vacancies that I have handled. You can just
So,
simply mail me and I can accordingly.
sure.
I just read the mail and just revert back as soon as possible.
So we have reached the end of the podcast, and the last question: what is your one advice for all the law students and also for the students who are about to pursue legal studies, who have just completed their 12th and are hoping to get into the legal studies? So, what is your one single advice for them?
See, the law students who are about to clear the graduation, who are about to pursue the graduation, so they have to obviously the reading part is fine going on for reaching to the ladder of success. You can't miss the reading. You have to read the judgments thoroughly. Every single day, you have to read the judgments of every state's high courts, like it's a tribunal, consumer forum, to get the basic knowledge of the law, the Consumer Protection Act, like this Tribunal Act, so NGT Act also. So for that you have to read a lot, read and draft. This is the most two essential thing to reach to the ladder of success. And apart from that, you can the those law students who are in the first year, second year, third year, they can start reading it. They can participate in the moot court competition because it really helps them a lot in building up their confidence, which would which would be beneficial for them in the later stage of life when they decide to join the litigation or any other field, either in the corporate law or any other field. So reading is the must. Reading the judgments and drafting are the two things because you have to draw the line between judgments. You need to go through from top to bottom. You need to understand the rationale of the judgments. You need to read. You need to interpret and understand the rationale of the judge's opinion, what they have tried to interpret in that judgment. Sometimes, if you are making memorial in the moot court competition, if you have to, like, if you are paying for the petitioner, and so you have to set out certain grounds on which you are relying upon. You have to cite out certain judgments on your favor. So you have to read entirely the judgments. As number of judgments you will read, your memory will get sharp and you will succeed in the legal profession. Without reading, it's hardly you will not sustain legally. You can argue as much as you can argue in the court, but if you have to sharp your legal arguments, you have to read thoroughly.
So, reading is the most important
It
aspect.
is
The
the
most
most important point. One should not leave reading even after graduating.
And sir, also for the people who are about to start their degree studies, the people who have just completed their 12th, what suggestion would you give for them if they are wanting to pursue legal studies soon?
Legal friend, but they should make they should make themselves clear that where they want to head, whether they want to join judiciary or they want to join to the higher judicial services, whether they want to go into the corporate law firm. But in fact, that also you have to read. You have to read continuously. You have to read, at least you should read 5 to 6 judgments in a week or in a day. It's very tough for the law students to read 20 judgments in a day, but at least 5 to 6 they should read. They should read constitution judgments. They should read the basic judgments, the leading cases like Krishna Bharati and other relevant cases which have formed the which have formed the constitution overall. So they should start reading and they should start drafting it. They should make the notes also. It's all about analyzing the legal points and how to put forth your points and how to briefly make the notes from the judgments. So you have to be very sharp and you have to be very crisp and clear.
Okay. Sir, so there was one of the major questions that I wanted to ask is, being a lawyer, how do you keep your conscience aside while fighting a case?
See, it's a professional ethics. An advocate has its professional ethics and his moral and social duty to defend a person accused, regardless of the personal opinion that I may be having against my client. So it's a duty which is being imposed by as per the Advocates Act also. So an advocate should always remember that his loyalty to the law, which requires that no man should be punished without adequate evidence in the trial. So our conscience should not be more vocal. It should be within the parameters of legal profession. Because as per section 39 also of the constitution, which provides representation through legal aid to the marginalized section of society, which those people who cannot be represented by such lawyers, so they are also being represented through legal aid. So it's the constitution guarantee provided by the Indian Constitution. So that thing should not come to the in the mind of a lawyer. So regardless of personal opinion, whether he has committed a crime or not, he should be readily available to defend his client at the most priority.
So you have been doing law for, like, you're practicing law for 10 years now. So how has the mediation and out of court settlements helped you in solving cases?
So mediation, I have been doing mediation since I have entered my foot into the practice since 2016. I've done few matters of mediation in the family courts of Saket, in the family courts of Patel House also. So it is one of the best form of settling the matter out of the court, which I think otherwise it will be it, otherwise if you go through the litigation, it's a tedious process and it takes years and years to settle the matters, especially the matrimonial matters. In fact, our CJI Chandachud also emphasized upon the mediation thing. He has been doing so from past several years. So mediation, after arbitration and conciliation, mediation is the second best alternate adjudication forum to settle the disputes. So mediation should be the best way to settle the matrimonial disputes. Otherwise, if you talk about in commercial act, there's a provision of pre-mediation settlement that's already in the statute. So there is a condition applied already in the commercial disputes matter that first you have to go to the pre-mediation thing. Then you can file a suit before the respect confront authority, confront court, and so on and so forth. So I recommend mediation would be the best form of settlement in coming years. Otherwise, to litigation, the case is going to be piled up again and again, and There are already number of cases piling up in cases of matrimonial matters. So it would be good if lots of matters to be settled either through Lok Adalat or through mediation. Because in the end, we have to save the family, the marriages. That's what's main utmost priority of every lawyer is.
So
So
because litigation makes the matters go for a longer time, that's why you prefer mediation
that's
over litigation.
in fact the five judges bench judgment which came long time back, where there was a 25 years of marriage and there was no chance of marriage being saved from. Both the parties were not able to save their marriages after spending 25 years of together. So there was irretrievable breakdown of marriage. So in that case, the Supreme Court exercised its statutory power under Article 142 and gave them, and they both were divorced. So they went to the mediation after that, and in the mediation committee, in the Supreme Court mediation committee, so both the parties were settled. So Supreme Court also conduct mediation programs and the SCLC also, Supreme Court Legal Service Committee also. In that also mainly legal aid matters, which consist of mediation. They come up and mostly matters have been settled through mediation in the Supreme Court itself, not in the district courts. That's a separate issue.
So because mediation also saves time and
Because
it
yeah, because I have seen
reduces the cost.
personally in the district court, so there are 4 5 dates. Even there are 4 5 dates before the mediator in these district courts. Nothing happens, and this matter goes to the main court without reaching to the conclusion. So if both parties agree to each other, their settlement, whatever is being agreed by both the parties, by both husband and wife. So it's a good thing. There will be less number of cases, especially in family matters. That's all what I have to say.
Sure. So because mediation saves a lot of time and it also saves the family first
Lot
of
of
all.
money also, lot of time, lot of emotional distress, and all these things saved
Yes,
from.
sir. Okay, sir. Yes, law career. Why do you think it's better than all of the others?
Because especially mediation can only be worked in matrimonial cases, and these kinds of sensitive cases needs to be dealt through settlement only. Otherwise, there is no point to stretch the matter for 10, 20 years. And despite that, also nothing works out.
Yes, sir. We've started the recording again. So one question that I would like to take up is,
Yeah.
as you have been doing litigation since 2012, and then you're also doing your practice after 2020. So how do you stand with the question of digitization of courts? How much is it helped you, and how much is it like on the badder side?
See, when I started practicing in 2012 itself, there was no noise about the digitization of courts. We were doing filing physically, and there was a time when it was all physical filings were there. But CGI has already emphasized upon digitalization of courts in the year 2005 itself by setting up Supreme Courts of India's e-committee. That I came to know much earlier in my practicing as a practitioner. I came to know much later about this thing. So the e-committee has also proved a digital preservation standard operating procedure that will scan, store, retrieve, digitalize court records while preserving legacy data of the judiciary. Now, post COVID, everything has changed. Apart from legal education turned out to be very versed in the now the law students they used to give the exams through online mode, where there was a error of cheating also could have been. The law student mostly used to have referred the books also while giving the examination. So it was very tough time for the legal education to survive through to transform itself from physical to online mode also. So recently also Delhi High Court has adopted certain measure of centralized filing system for ongoing cases. And Delhi High Court has ordered district courts to adopt this system for a while because we have seen enormous tremendous technological developments that has transformed the lives of millions of legal professionals. And as of now, as practitioner of Supreme Court, we used to carry a bunch of files to the court. We used to carry a heavy bag with lots of files in it. Now you just need the iPad or laptop and a 2 MB file of your file, and it is easy to carry, and the it is to carry and it is to show to the court, to the bench, that this is you don't have to mark anywhere. The pagination is very simple, and video conferencing has been more accessible, and it is more up. It is already a perfect mode of in adjudication of justice system. So video conferencing during judicial proceedings has further reduced travel expenses also, allowing parties to participate in the cases remotely. So this transition, we are still going through it, and because the transition of digital records has also led to substantial cost reductions associated with maintaining physical archive, storage, and infrastructure. Because in
So
2018
basically,
itself, the judgment, the initiation took place by the CJI D.Y. Chandrachud, when it itself allowed the live streaming of constitutional cases and cases of national importance, except POXO cases and sexual related cases. So the time, this is the transition phase, we are still going through it, and it will take some more time to adjust this era of this judgment of Swapnil Tripathi versus Supreme Court of India. In this case, the CJI Dr. D.Y. Chandrachud has allowed live streaming of constitutional matters in case of national importance, but not those cases which are related to POXO related cases and sexual assault cases. They are not to be allowed live streaming.
yes.
So COVID-19 was an era where the digital justice system was about to organize, about to initiate comments. Ecosystem has already been established, but the infrastructure that we require is still not completed. It will still take time for the infrastructure of IT to settle it down, because we have seen so many repercussions and the negative side of it during the COVID time in the two, two, 2020, say till 2022, we have seen this lots of uh, lots of errors during this online hearings. So it will take some time to settle it down. Mediation has helped litigants, legal professionals, and law students also, so they can easily access and they can easily learn the constitutional matters by accessing through the live streaming of constitutional cases also. So it has become very feasible for them to to learn the nuances of laws, constitutional judgments by just simply going to the Supreme Court website and just click on that live streaming website, and they can access it. So we have pros and cons of digitalization.
So just to summarize, the pros are you don't have to preserve the files anywhere, you don't have to carry a lot of things, and it
Yeah,
decreases your travel expenses. And for
yeah,
the negatives, we do not have adequate infrastructure as for now, and there are some errors that we have seen recently.
yes. That is the main purpose of the main purpose is all about implementation. How far we'll go to implement this digitization of Indian courts. This has been focused since 2005, but we are moving towards that road of digitization. So let's see. For that, legal profession in India, legal education has been uh, seeing drastic changes since 1987 to 2021, post-COVID era. We have come a long way. If you because earlier what we used to have course only LLB course in 1987. We don't used to have integrated LLB course, because in 1897, upon the suggestion of the Law Commission of India, and to address more to improve more legal education and to raise the academic standards of legal profession in India. National School of National School of Bangalore, it introduced integrated law course for the very first time. And after that, other law colleges followed that pattern, like MT Law School, IP. So we have this integrated 5 years law course. So there was sudden change from LLB 3 years LLB course to 5 years LLB course.
So, sir, basically, we also heard in your question that you were saying that law is a noble profession. So, why do we always hear lawyers say this particular thing?
The law, there are two professions which are called as noble profession, which is, one is medical, and another is legal profession. But legal profession has always been kept on a higher pedestal as a noble profession, because the purpose of the law in society is to maintain the moral sanctity which regulates society. Therefore, it is we are the upholder and protector of law. If we don't do that, who will do it? Because we provide service to the nation, we provide service we owe our duty towards towards the court, to the client, to the nation, and we have to play a significant role in shaping public policy and influencing legislative decision also, to promote fairness and equality in society. The legal profession serves a pillar of democracy, ensuring that everyone has access to justice and the protection of their rights also. But if we see overall over a past few years, there has been incidents against the advocates also, where despite there has been an Education Protection Act which has not seen a light of a day, and the advocates are being targeted by the goons, by their own clients. I think there have been so many incidents where, but I think there was one of the advocate who was shot in a daylight. It was a, it's a matter of a thesis. So the especially the one who practice in criminal law, they have to face repercussion. And these days, the legal profession is in a very what you say. The justice system has to revolve. The criminal justice system has to revolve, because if the lawyer who is protecting, who is safeguarding the accused in a trial, in a criminal trial, and if that is not safe, then who else is safe? So the Advocate Protection have Act has to come as early as possible, keeping in mind all the incidents that has happened against the advocates.
So, how do we relate this Advocate Protection Act to the advocacy being a noble profession?
Because uh, it is not a different different advocacy act advocacy no sorry advocates act and advocacy is not different altogether. It is governed by Advocates Act. If I talk about the Protection Act, so there are certain measures the legislation have to think about for the welfare of the advocates, and because Advocate Act talks about certain things, the duties of advocates, which is already there in Advocates Act. In Protection Act, what measures through legislation, what measures they have taken in the favor of advocates, how well they can advocates can be protected under those under that law. So that has to be seen very minute.
Sure. So, thank you so much for taking out time from your busy schedule for this podcast. And this would be very helpful to all the students. And once again, I thank you from on the behalf of my whole team of Project Nyay, and regards from Pavan SS and Kamal Aditya too.
Thank you so much, Akarsh, Asar.